Hello, I'm Tricia Bigelow from the 2nd District Court of Appeal, and with me today is Richard Couzens, also a judge retired from Placer County. We're going to talk to you about the new Prop 36, and the new Prop 36 is an amendment to the California Three Strikes Law. Prop 36 brings about two major changes to the Three Strikes Law. Changes that have not been made to the Three Strikes Law since its inception almost 28 years ago. There have been no major changes to it since that time, but we're presented with them now. And let me explain to you the two major changes. The first is there's an amendment as to who qualifies to be a third strike offender subject to a 25 to life sentence. Now, only those persons who have been convicted of serious or violent sentences will, on the current offense, will be eligible for a 25 to life sentence. All other defendants will be sentenced as second strike offenders.
Trish, does this mean that if the current crime is not serious or violent, even though the guy has 6, 7, 8 prior strikes, the sentence still would be as a second strike offender?
It seems unusual, but that is in fact the case. They could have a history of 6, 7, and more serious or violent felonies, but if the current offense is not for a serious or violent felony, they would be treated as a second strike offender. The second part of the major changes is that it allows certain defendants to petition the court for resentencing as a second strike offender. Let's talk first about the effective date of the statute. As we all know and voted on Prop 36, it was on November 6. Pursuant to the plain statutory reading of the words of Proposition 36, that statute becomes effective the next day, November 7th, 2012. Interestingly, in this statute, there is no savings clause, and by that I mean there's nothing in the statute that says this is to apply only to those offenses occurring after November 7th of 2012. Given that there is no savings clause, the Supreme Court case of Estrada would apply, and this new statute will only be applicable to cases that are not yet final, or I should say it will be applicable to all cases not yet final as of November 7th, 2012. That brings about a very important difference for certain defendants. Cases are considered not yet final if they have not been resolved by a traditional appellate review process, allowing for time for a petition for rehearing, a petition for review by the California Supreme Court, and even the time to file a writ of certiorari before the United States Supreme Court. So there's a large window of persons who will have their sentence being subject to this offense where their cases are not yet final. And it does make a difference. It makes a difference because, as you will see when we talk about this in the future, persons who have to petition the court for resentencing are required to demonstrate to the court that they will not be an unreasonable danger to the society. Or actually what happens is the court is going to make a determination of whether or not resentencing is appropriate, and resentencing must be granted if the defendant is not an unreasonable risk of harm to society. This important distinction does not apply to those cases that are not yet final. As to those cases that are not yet final, that threshold showing will not be required to be made, to be determined by a judge or otherwise. Those persons whose cases are not yet final simply qualify for resentencing under the Three Strikes Law.